Carney?
I am, Your Honor.
Mr. Sharp?
Yes, I am, Judge.
First thing I'd like to address is the 330 motion. Go ahead, Mr. Sharp.
More to submit other than our response. Thank you, Judge.
I would like, for the record, to indicate that I have reviewed the materials.
Your Honor, first the people would like to the court and direct the court to all of the victim impact statements that were submitted in this case, Your Honor. The victim's family is here present in the courtroom, Judge, and it is their determination that no one wishes to speak here at sentencing, Your Honor. And as a result, Your Honor, the people would ask that in Your Honor issuing sentence, consider all the victim impact statements that were submitted in this case, as well as all relevant factors and all the evidence that came out at trial. And in particular, Judge, I would just like to point and direct your attention to the defendant's pre-sentence investigation. And during his pre-sentence investigation, still today, this defendant does not admit responsibility for causing the death of his wife, Angela Morgan. Your Honor, it is very clear, based upon the evidence at trial, the fact that a jury of his peers found him guilty of manslaughter in the first degree, indicating that he, the defendant, caused the death of his wife, Angela Morgan, in 2008. And even based upon all the evidence that was adduced at trial, he still has absolutely no remorse for his actions and still has not admitted any guilt with respect to what he's been convicted of before, Your Honor. As a result, Your Honor, in considering all of those factors, the people respectfully request that Your Honor sentence the defendant to the maximum period prescribed by law. Thank you, Judge. And there's an order of protection to be issued on behalf of the victim's family. One has been uploaded and is available for consideration for Your Honor.
Thank you. And nobody is speaking other than the innocent party, is that correct?
I'm sorry, Judge?
No other victim impact panel people will be speaking?
No other victim impact statements other than they're all been submitted to Your Honor and I believe were made available through the probation department in addition with the pre-sentence investigation. Thank you, Judge.
Mr. Sharp?
The district attorney started, which was responsibility as reflected in the pre-sentence investigation report. As the court is well aware, attempts were made prior to my representation of Mr. Morgan, and attempts were made after my representation of Mr. Morgan repeatedly to seek a resolution of this case to manslaughter in the first degree, to accept responsibility pursuant to a plea agreement in front of Your Honor. And as you know, all those attempts were flatly rejected by the district attorney's office because they have a policy, which is their prerogative, and that is fine. Mr. Morgan, as I instructed him, did what I told him to do at the pre-sentence investigation report, which is simply to not make any statements of fact or anything like that, because he's obviously going to file an appeal. If that gets reversed, those statements could be used against him, Judge. So that was my decision. I directed him to do that, too. Repeated attempts were made to try and resolve this case, to avoid a trial, to give everyone a sense of finality, and those were rejected. That's fine, that's their prerogative. But to say that he has not accepted responsibility, I think, under these circumstances is understandable. It's right not to under these situations where he's been convicted after trial. Our attempts were made to try and avoid a trial and to plead to manslaughter in the first degree, which ultimately we went through a 3-week trial, and that's what he got convicted of. So in terms of fashioning an appropriate sentence, Judge, I would point you to a few things, one of which is Mr. Morgan has no prior felonies. He actually has no convictions involving violence. He's been incarcerated for 14 years almost at this point in time, and as the court is aware, has had no behavioral issues in Columbia County Jail, where he's been the last 5 years, or previously in the Department of Corrections. I'll also note, Judge, the sentencing parameters here promulgated by the legislature, a minimum could be 5 years. The maximum is 25. There's a broad range in between. When we did attempt to ask Your Honor for a plea to the murder charge, Judge, and you had indicated your sentencing recommendation or sentencing proposal, if he accepted responsibility to murder, would be 17 years to life. And ultimately, no, we did not accept that, Judge, frankly, because our position has always been, and Mr. Morgan's position has always been, that he didn't murder his wife. And so to come in court and under oath and say that and to accept that type of responsibility is not something he was willing to do. And frankly, the jury agreed with that after a 3-week trial. But Your Honor, I think, recognized appropriately that he's not deserving or warranted of the maximum sentence in this case. And as I pointed out, there's a range between 5 and 25, Judge, and I just think that imposing the maximum sentence here, as the legislature has said, in this type of case, can be significantly less than 25 years. To impose the maximum is unwarranted. And thank you for listening to my comments, Judge.
Thank you. Mr. Morgan, you have a right to be heard before I impose sentence. You wish to be heard?
No, thank you, Your Honor.
Thank you. I'm going to ask that you stand then. I have been responsible for this case for several years as the trial judge in anticipation and then the trial judge. I have reviewed the file as it relates to the most recent retrial. I sat through the trial. I have reviewed the pre-sentence investigation together with all of the victim impact statements that were submitted, both with regard to the pre-sentence investigation and 2 or 3 that were submitted thereafter. I come to only one conclusion, and that conclusion is that the appropriate sentence under these circumstances is that you be committed to the Department of Corrections and Community Service to be incarcerated for a period of 25 years together with 5 years post-release supervision. I am directing that you pay a fine in the amount of $5,000. I will execute the order of protection that has been uploaded, which will be for a period through 2041. I'm requiring you to pay all appropriate surcharges and fees, and I'm advising you have a right to appeal. Anything further, Mr. Carty?
Judge, if I could hand up the notice of intent with respect to appeal. No, thank you, Judge.
This proceeding is concluded.
Thank you, Judge.
You can take him downstairs with his comment.